welcome. I'm Mielle Marquis. I'm the Director for External Relations here at Northeastern. I wanted to do a very brief welcome. This is probably our School of Law's 7th or 8th year hosting an annual labor and employment program, which grew out of a conference that we did approximately 8 years ago, which was a great kickoff, and we've remained committed to it. We are fortunate to have so many graduates and as well as students that practice in this important area that has been highlighted in the news so much recently and many other areas. I wanted to thank all of our speakers for participating and for some traveling in for us. Thanks, Olivia. I know we had train issues today, so thanks for being here. I also wanted to especially thank Mark Irvings, who continues to spearhead this program, even while recovering from a very recent surgery. Thank you, Mark. You're amazing. I wanted to thank our sponsor, Morgan Brown and Joy, expecting Joe McConnell shortly. They generously supported the networking reception that follows the event. We couldn't do it without them. I wanted to thank Professor Carl Clare for all he's done in this field and for helping us publicize the event. Carl, thank you. As well as Ira, who remains a committed team member and always does a great job to come up with ideas and topics and help us promote it. So thank you. We have a few students joining us tonight. If you're a student, please raise your hand. I expect a few more. Wow, great job, guys. So they're here to network with our experienced practitioners. I'm sure more of our practitioners will arrive shortly, but be extra kind to our students, and it's great that we see them here. I also want to just briefly mention we have a networking event for students called Connections. It takes place April 4th at Foley Hoeg. We'll have several labor and employment tables that need to be staffed by all of our graduates. So sign up for that. We sent out a notice this week, and we hope you'll see additional ones shortly. I just want to mention we also have an alumni referral network. There was a sign up at the registration table. So if you're an alum and you refer cases to other alums, that's a great chance to participate in that and sign up down at the registration desk. I will now turn it over to Mark, our moderator, to introduce our panelists. Thank you, Mark.
Okay, thank you very much. Thank you all for being here. Hope we get a few more people coming soon, because these are really good panels. As we say, this has gone on for many years. We try and take timely topics and get practitioners who have something to contribute in those areas. We encourage there to be questions along the way. If something occurs to you, you don't have to wait till the end. Raise your hand. We'd be happy to have the contribution. It's supposed to be interactive. So the first panel on the working around uncertain or unfavorable courts agencies in Congress. I'm sure you have no idea what we mean by unfavorable courts agencies in Congress, but that'll be explained too. But our first speaker will be Olivia Singer. I'm not going to take the time to go through their bios. They're well succinctly stated in the program, but is going to be speaking from the union side perspective. We're going to have Jim Weliky, who is in the firm of Messing, Doskin, Weliky, will establish plaintiff's firm dealing with the issues, I think, particularly of what happens in dispute resolution and mandatory arbitration. And Kevin Burke, who's at Mendelson, who will be giving us the employer's perspective on that, and also issues of elections and the neutrality agreement, things of the sort. So with that, Olivia, take it away.
Sure. Thank you for having me. I work at Local 32BJ, a building service union with headquarters in New York. And one of the primary workarounds that 32BJ uses are card check and neutrality agreements. So I'm going to talk a little bit about how our union uses those agreements. The current strategy that we use started with the Justice for Janitors campaign in the late 1980s, early 1990s. The problem that we were facing was that a lot of the work is done by contractors but the money came from building owners. So building owners would, as soon as a contractor became unionized, would switch over to a new contractor, and the NLRB election process would often be too slow to allow for the kind of results that we wanted, lasting results for the contracted workers. So we had to think about a new strategy that would allow workers to have a union and then retain that union rather than having their contract terminated as soon as they were able to gain recognition. So instead of having a contractor by contractor strategy that was too slow, they moved to a market-wide strategy to try to get, rather than just one contractor recognized at a time, to create uniform rates throughout the market. So focusing on a city like New York and achieving an industry-wide recognition and ultimately master agreements. So in order to achieve this goal, the workaround that was used were card check and neutrality agreements. So I'm sure a lot of you know what those are already, but a card check or neutrality agreement is an agreement where the employer agrees to voluntarily recognize the union for a group of workers upon verification that a majority of the entire group of employees has signed union membership cards. In addition to agreeing to recognize the union, the employer will agree upon a showing of those cards to bargain a first contract. So there's not the problem of having a union recognized, but then a long push to try to get the employer to the bargaining table. The neutrality component means that the employer will not interfere with the employee's choice as to whether they'd like to have a union or not at a particular workplace. And the union in turn provides labor peace. They won't promise not to disrupt the workplace and won't engage in strikes, picketing, boycotts, things of that nature once the agreement is signed. And instead of having injunctions go to court, there's an agreement that any dispute as to how the agreement should be applied is through an arbitration process. One of the things that obviously convinced employers to sign on to this was action by workers in the cities, starting in Denver. There were actions in Atlanta, Los Angeles, Washington, D.C. I'm particularly knowledgeable about the Washington, D.C. actions. They involved civil disobedience, blocking highways, also more traditional pickets, and one of the ones I find particularly interesting, since janitors often work at night, they would do nighttime marches to raise awareness about the fact that workers were going to work when a lot of us were at restaurants or drinking. So you'd see people with lights in the streets, and it brought attention and put pressure on both the building owners and the contractors to consider signing these agreements. An important part of the agreement is something called the trigger provision. Not all of the agreements included these, but the ones that did had an agreement that the what we often call the employee free choice procedure. It's also known as a card check process. It wouldn't begin until the union had demonstrated that they not only had a majority, that they had a majority of contractors in a certain area. So it gave the contractor the promise that if they sign on to this agreement, they won't immediately be put in a position where if there's a showing of a majority, they won't have a competitive rate and they'll be kicked out of the building, as the problem was before. Some of those same trigger provisions were then put into some of the first collective bargaining agreements in connection with what's called a Kroger clause. pretty much saying that any new accounts that an employer obtained, they would agree to also voluntarily recognize at those new accounts, and that would only happen, this voluntary recognition, if, similar to the other trigger provisions, the new county where they'd gained their accounts, the union could show that they had signed agreements with a certain percentage of the contractors, typically about 60%. So through intense work by workers over the course of many years, Justice for Janitors was extremely successful, and now in many cities we have master agreements, and a large number of contractors are unionized. So with that in mind, the union then took the same strategy to help to organize security officers. Security officers had a slightly different problem than the janitors. For security officers, under the National Labor Relations Act, Section 93 says that a union who represents non-guards can't also represent guards. So since Local 32BJ represents janitors, for example, we couldn't have a certification by the NLRB for an election for a bargaining unit of security officers, but we consider them an essential part of our building service work. Most buildings have a janitor and also a security officer. So our strategy again was to get these card check agreements signed, using traditional union strategies to convince both the contractors and also the building owners to come to the table, and then insist on card check rather than going to an election, and voluntary recognition. And again, the same trigger provisions to ensure that there was a certain level of density so that the security contractors could remain competitive. And the most recent example, that again was very successful. We were able to get master agreements in the New York area and other cities. But the most recent example we have now is our airports campaign, which we've been running for about the past decade, and have recently signed some of our first master contracts. So it's very exciting. Airport jobs used to be really great jobs with decent pay and benefits, but over the past few years, decades, there's been a shift to using contractors. Instead of having work performed by the airlines, they'll contract out to a group that will do the wheelchair attendant work or the cleaning for an airport. So at around 2010, for example, a wheelchair attendant would make maybe $4 an hour. They'd get tips, but at really low rates. But the problem with organizing airports is that the airport is considered under two regulatory schemes. There's the National Labor Relations Act, but then there's also the Railway Labor Act. And the Railway Labor Act requires that there are industry-wide bargaining units. So it's very difficult to organize contracted employees who don't have a connection to other employees who work for the same contractor, say in San Francisco, who are based in New York. So again, we sought the card check agreements and neutrality agreements to push for uniform standards. And now we have 10 contractors at Kennedy and LaGuardia in Newark, and more to come on a master agreement, and at least 4 security contractors with a similar agreement. And we have a similar approach that we're currently implementing in DC and Pennsylvania. So that's a bit of an example of the work that we're doing around card check and neutrality agreements. Thank you.
Okay, before we go on, any questions? Let me ask you this. In the airports in New York, are the contracts now with each contractor, or is there any intra-contractor mobility? I mean, does anything cover
So we have a master contract that has been signed on to by 10 contractors. It's a master contract that was bargained by all of those contractors individually. They each had their representatives. It was a huge undertaking to have all of these contractors bargain together. In some cases, you'll have a master agreement that's bargained by like a employer association, where the employers will come together and choose a representative to bargain for all of them. But in this case, it was all separate contractors. So.
Great. Thank you. Yes, please.
So obviously, other than like economic weapons of employees, what were some strategies that you used in convincing employers to voluntarily recognize the union?
Sure. So another big arm of our fight has always been political efforts. That's been something that we've definitely used at the airports. Working with the Port Authority, and once wages are at a certain level, it's a lot easier to convince an employer to join on to an agreement. So that's another example. Sometimes employers are interested in joining our fight, but a lot of it is just traditional strategies.
Okay, Jim?
So I'm a plaintiff's employment lawyer, which means I represent unorganized workers or employees, mostly in the private sector, but some in the public sector. And what we deal with every day is vast disparities in power between our clients and the people we're opposing. It's a disparities not just in terms of and that manifests in a number of different ways, including financially, because obviously our clients have fewer financial resources than our opponents, who tend to be employers with more resources, or insurance companies. It's knowledge. Employers typically have access to all of the information that we need in order to successfully litigate our cases. And it's emotional and cultural barriers that our clients sometimes have to fight against because they're taking on employers. There's a cultural people who make a living out of studying juries and popular cultural attitudes towards litigants say that there is a predilection for people to think of plaintiffs or people who are suing their employers as complainers or whiners, and even the people doing it themselves feel somewhat disloyal. The great thing about what unions did, and I say that the past tense advisedly, is that they helped to rebalance that power, and one of the ways that they did that was obviously banding together and forcing the employer to come to the table because they had more economic power. And in the course of that, they had a system for mediating disputes, or for resolving disputes, called arbitration, which I'm sure you've all heard of. And it was a way to, even when disputes arose, there was less of a power imbalance than there is in the unorganized sector. So one would think that having more arbitrations in the private sector would be a good thing as well, because I guess the argument is, and Kevin, you can educate me on this, but I think that part of the argument is it's more efficient, it's cheaper, so at least the financial barriers to entry are less. It's a little more informal, so it doesn't require as much resources to successfully litigate. But from the plaintiff's perspective, arbitration for non-union employees is not a great thing in most cases. Now, voluntary arbitration between people with means and resources is one thing, but what we call, in a completely neutral characterization, forced arbitration is not great when the people who are being forced into arbitration are people with little or no bargaining power in the relationship, who sign agreements as a condition of employment or a condition of continued employment. In that case, you don't have the bargaining power to say, okay, I'll do it, but I want to make sure that the rules of civil procedure apply, and I want to make sure I get punitive damages and all. Basically, the employer comes and says, take it or leave it, and the person usually takes it because they need a job. Who doesn't? So, involuntary or forced arbitration is not a great thing for our clients for several reasons. One is what I just described, is that it's not voluntary. The second is that quite often, in my experience in the arbitrations I've done, at least in the employment area, they're not faster, they're not less expensive, or not that much less expensive than litigating in court. Plus, they have the disadvantage of no rules of civil procedure, no rules of evidence, although the rules of civil procedure and rules of evidence shape the hearing or the arbitration, but arbitrators aren't bound by it. There's no real right of appeal, and there are some incentives, present company excluded, for arbitrators to split the baby. Because, the arbitrator's got to make a living as well, and if an arbitrator gets a reputation for always ruling against the employer, that arbitrator is not going to be chosen when it comes time to choose an arbitrator in the next arbitration. So there is some incentive, and I'm not saying anybody in this room is subject to that, to not give the full relief or the full measure of justice that a litigant might require. So those are just some of the few of the reasons. I could go on longer, but I'm supposed to talk about the legal landscape with respect to forced arbitration, so I will do that. The issue of whether or not individual employees can be required to arbitrate claims has been one that's been developing since the early 70s. Back at the beginning in the 1960s, there were a series of cases called the Steelworker Trilogy, which essentially said, set the rules for union arbitration, got courts out of the business of getting involved in individual arbitration results, and set, union and collective bargaining arbitration as a separate sort of culture and means of resolving disputes that never, it wasn't thought until until 2009, I guess, that the deference that the courts showed after the Steelworkers Trilogy towards arbitration would be applied aggressively against individual employees. And there was a case in 1974, Alexander versus Gardner-Denver, that said specifically that collective bargaining agreements don't preempt statutory discrimination claims. So up until 2009, when the 14 Penn Plaza case came out, that was essentially the law of the land, that even if you were a union member, you could still litigate your Title VII claims. And of course, individual non-organized people could do that as well. But in 2009, in the 14 Penn Plaza case, the court actually said for the first time that if the collective bargaining agreement clearly and unmistakably says that discrimination claims are subject to the arbitration provision, they have to be arbitrated under the arbitration provision. And my two labor lawyers can correct me if I get any of this wrong. So that was in the collective bargaining context. In 1991, in the private context, a case called Gilmer versus International Johnson Lane had said that age discrimination claims could be the subject to mandatory arbitration, but that didn't apply to employment contracts. It applied to stock exchange application agreement that had a provision that said if you want to be a member of the New York Stock Exchange, you've got to agree to forced arbitration. But Gilmer did not say that that would apply to ordinary employment contracts in the ordinary course of events. As well, it shouldn't have, because there's a provision in the Federal Arbitration Act, which is the act that governs the enforceability of arbitrations, that says specifically that the law doesn't apply to employment contracts. At least that's the way I read the provision, and that's the way the plain language of the provision reads to me. The Supreme Court disagrees, but it says clearly that the statute doesn't apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. And as we all know from our constitutional law class, the Commerce Clause applies, everybody is involved in interstate commerce. So of course that means that employment contracts aren't governed by the FAA. In 2001, the Supreme Court said, in the Circuit City case, said no, that provision, that exclusion only applies to transportation workers. Everybody else is fair game. Again, I'm just a country lawyer, and that's not the way the language of the provision reads to me, but what do I know? So since that time, us plaintiffs' employment lawyers have been fighting a sort of long, twilight, desperate rearguard struggle against the encroachment of forced arbitration into all aspects of the employment relationship. I won't go into it in detail because it's depressing, at least for my plaintiffs' colleagues. For management, if you want to pick me up, I can talk about it more after the session. But suffice it to say that now the law of the land is pretty much, if you sign an agreement that says you have to arbitrate your disputes through forced arbitration, it's enforceable unless it doesn't meet certain minimum studies of standards of notice or due process standards, and as long as it's knowingly and voluntarily entered into, where voluntarily, yes, means if you sign it as a condition of employment, that's still voluntary. But one area where forced arbitration had not encroached until quite recently was in the area of collective actions or class actions, which, as you all know, is a way for people with limited resources and sometimes low damages to band together to actually get justice and relief in a way that they couldn't as individual plaintiffs. And because one of the rules about forced arbitration was that it's not enforceable if it limits the availability of remedies for your injury, it had long been the rule that any arbitration clause that says you can't, or at least this had been the argument, any arbitration clause that says you can't engage in collective action was unconscionable because it limited the scope of the remedies that you had available to you. So in the last few years, the Supreme Court has come out with a number of cases in the commercial context that has said, no, not really, those are fine too. In the employment context, there have been a number of district court and circuit court cases that have said the same thing. In 2012, back in the good old days, the NLRB, the old-timey good old days, the NLRB came out with a decision that said that forced arbitration or arbitration clauses that prohibit that deny people access to collective action were violations of Section 7 of the National Labor Relations Act, which is the section of the NLRA that says that employees have a right to work together for mutual aid and assistance. The Fifth Circuit, not surprisingly, partially overruled that, and then overruled it more in a case called NLRB versus Murphy Oil. Other circuits disagreed and bought the NLRB's reasoning. So there was a circuit split. The Supreme Court took the case Murphy Oil and another case called Lewis v. Epic Systems, and a third case consolidated them for a hearing on this issue, which was held on October 2nd of this year. Interestingly, at the hearing, the Solicitor General argued on the side of the employers, and the NLRB's General Counsel argued on the side of the employees, even though the Solicitor General had originally represented the NLRB in the petition for cert. So we had the employers and the Solicitor General on one side and the NLRB and the employees on the other.
Can I just mention
yes.
for the record that the General Counsel of the NLRB who argued the case is a graduate of this law school. Very, very proud.
Interesting. What is his name?
Dick Richard Griffith.
Okay. So what the employers said in this this argument is that the jurisprudence about the under the FAA has always been that the FAA. Mark, am I out of time, or should I keep talking?
Soon.
Okay. So there was much discussion back and forth, to and fro, and the general consensus seemed to be at the end of the argument that it wasn't looking good for the employees and the forces of justice, and so we predict that likely the decision is going to be that arbitration clauses that prohibit class relief and class actions are not a violation of the NLRA. So there you go.
Given that John Roberts, when he was representing employer coalitions, whatever, was the architect of the mandatory arbitration with class action waiver, I would say it's probably a safe bet.
Yeah. I mean, one of the people who reviewed, who gave a review of the oral argument said, well, Gorsuch didn't really say much, and Thomas didn't say much, so we don't know how they're going to vote on it. Yeah, okay. Take what we can get. Anyway, sorry.
Go ahead, Maria.
Jim, are there any cases that deal with arbitration provisions that are contained in the employee handbook as opposed to an agreement or employment application?
I don't know the answer to that question. I can't imagine that there aren't.
I've seen this recently crop up in the employee handbooks, and there may be a separate document saying I've received the employee handbook, I agree on the
way the jurisprudence goes, if it's drawn to the employee's attention and it clearly says, hey, you're waiving your rights to litigate your claims, then it'll be up to it.
And I don't know the answer to that question offhand either, but there's literally dozens of these cases that have been at, I think, even at the appellate levels, let alone the district court levels. So, because in this circumstance, despite the Fifth Circuit ruling, the NLRB continued to issue holdings, and it obtained the circuit split from the Seventh and Ninth Circuit. So, you might want, if you're looking for a specific factual circumstance, I know at one point there was 28 or more than 28 D.R. Horton cases at the various courts of appeals. So you might want to look there if you're looking for a spot-on match. But again, that decision is likely to come out early next year, and we'll see what happens then. If there's more questions, I'll defer, but otherwise,
go ahead.
Yeah, I just have a question, point of clarification. So the ethics case that you're talking about, I don't know it too well, but I poked around and read a bit about it over the fall. So what I understood is that there's a conflict between individual mandatory arbitration and cause of action that arise out of concerted activity of employees. So if you have an employee whose rights are sort of triggered in virtue of the fact that they acted in concert with other employees, and then their arbitration is on an individual level, do they have those Section 7 rights under the individual arbitration, or is I'm just kind of, I'm not quite sure how that's supposed to work. Like, is like, well, he does this right with individual arbitration, but that wasn't under labor practice in virtue of the fact that he, approached his employer with a group of
Was that directed at Jim or?
Oh, anyone.
I think and I certainly not trying to cut you off, but I think my answer to that would be it kind of depends on what the Supreme Court decides. The not the Ernst and Young case. The Epic decision was the Seventh Circuit, and the primary holding there was that there was a right that was violated under the NLRA, under the other concerted activity, catch-all provision of Section 7. So to the extent that the Supreme Court overrules that decision and says there was not a right because that was not concerted activity, then that would be kind of nullified.
Well, is the issue whether simply having a mandatory provision that bars collective action the trigger, or does it depend on what the particular claim is?
That's something that I might address. I don't know, I might not answer it, but I think, again, the decision of the Fifth Circuit is that there was no statutory right to engage in protected activity by joining into a class or collective action. The decisions of the Seventh and Ninth Circuits were a little bit different, but again, the Seventh Circuit was that there was concerted activity, there was some statutory right implicated by joining a class action, and therefore there was a violation of the act. So I think, whether it's the underlying question that was argued at the Supreme Court and was briefed by most of the amicus and I think by the parties in general was, is there a statutory right here embedded within the National Labor Relations Act? And I think that's the question. So I think it's difficult to answer, in my opinion, that Section 8 violation question, because we don't yet know whether the Supreme Court is going to say that there was or was not a statutory right under the NLRA to join on to a class or collective action.
But it is my understanding that I don't think any of I could be wrong about this, but I'm not sure any of the litigants in the three cases that were heard were actually asserting
they were not
an interest in starting a class action. It's not like they had a claim for class relief. The argument was, we can't be bound by this because it's not a legal provision. So under ordinary contract law, a provision of contract's not binding if it's not legal.
Okay, go ahead, Kevin.
Okay, so I was actually planning to start with, I'm obviously clearly in the middle here, which I think was very crafty. Thank you very much. When we had the phone call about this, I said, of course, Mark, you're going to pit me as the contrarian. And he said, well, no, don't think of it that way, but I think the odds are kind of against me here. So at the risk of turning off half the audience, I might go a little bit in the opposite direction and turn off the other half of the audience, completely marginalizing myself. But in any event, I'd like to start with Olivia, and I will address, I think the employer perspective of the D.R. Horton Murphy Oil cases. But with respect to the neutrality agreements, I know the write-up for this panel was, tools used by employers and employees to tip the balance of power. I would imagine some people in the audience would agree with me, perhaps Joe, you would be one of them. Neutrality agreements are not used by employers to tip the balance of power. That's something that, again, I'll address some of the things that Olivia discussed, and I certainly don't disagree with the tools, the economic weapons used by unions. But again, I think the characterization of a neutrality agreement as a weapon to tip the balance of power for employers is probably a mischaracterization. Neutrality agreements, as you heard from Olivia, I think that was an appropriate summary of what an agreement would entail, how they're obtained. If you think of it this way, as an employer, there's the National Labor Relations Act, okay, and the act prescribes certain floor that you have to comply with in order to act legally with respect to your employees in attempts at unionization. So anything you're providing or agreeing to beyond that floor is actually a concession. So if I'm agreeing with the union to a neutrality agreement, I'm foregoing some of my rights under the National Labor Relations Act. So again, does that sound like the type of mechanism an employer is going to use to tip the balance of power in their favor? I would lobby against that. I would say probably not. Employers reluctantly agree to neutrality agreements, and largely the reason is because of the economic weapons outlined by Olivia. I will likely characterize them differently, just a headline there. But again, employers agree to neutrality agreements because they want to avoid the reputational harm, the economic harm of those organizational tools and those economic weapons, which I'll get into later. But it's the corporate campaign. I mean, that's what we see these days. That's the tool by unions. And again, I'm not begrudging the tactic, but I think I'd like to shine a little light about what it entails. But before looking at the neutrality agreements more specifically and what they entail and looking at corporate campaigns, I think at its core, we're here at a law school, and I took a lot of classes from Professor Clare. Neutrality agreements are stifling free speech. They're stifling free and open discussion about unionization. So I think for those of you who are here as students, who are still sitting in this classroom, hearing the words bouncing off the wall every day, I would imagine that this sends you chills. Because I would imagine that Professor Clare didn't cultivate your interest in labor law by telling you that, hey, let's highlight all the barriers to free speech. Okay, I just don't imagine that that's the way that you're learning labor law is neutrality agreements.
We have our representative of the ACLU here.
So there you go. So I think that would be, honestly, and again, I'm not trying to skew this too much or be too contrarian, but I think that's a legitimate viewpoint from an employer or even from a union, that you are taking out of the hands of the employee certain opportunities that they have to vote in an election. And that is, again, stymieing free speech, just as Olivia said, a neutrality agreement would likely require an employer to take a neutral position in a campaign. So looking at neutrality agreements in more specificity, what are they going to encompass? Likely a full neutrality agreement that a union might insist on in order to forego any of the economic weapons it has would be limiting communications to your employees about your position concerning unionization. Agreeing to provide a list of employees in advance, which again, you are not required to do under board law until the union has a showing of interest. So again, absent a showing of interest, you would be agreeing to provide a list of employees to allow the union to connect with them, which you otherwise would not be entitled or obligated to do absent a neutrality agreement. Most neutrality agreements waive an NLRB election. So again, not only is the employer agreeing to not take a position with respect to unionization, but they're also agreeing, and the union is agreeing, that we will not hold a secret ballot election, so that the employees in the potential bargaining unit will not be exercising their free right to choose a union or not choose a union. There also might be a preliminary agreement about when bargaining is going to commence, which again, that's not something that's encompassed in a normal certification of representative following an election. And as Olivia said, and I think this is also commonplace, it's likely to include a Kroger agreement or a trigger agreement that says, okay, we're going to organize this site and then any future sites in a certain radius, or all your locations in Missouri but not the ones in Kansas. There's a preliminary agreement that any organizing at those sites will automatically fall subject to this procedure and or fall subject to an automatic recognition of the union. So again, from the point of the employer, and again from the academic point here, that agreement is stymieing free speech on both the employer and on the employee side would be the position I think most employer management representatives would take. Now, is that the only form of a neutrality agreement? Absolutely not. You could have a neutrality agreement that does agree to a board election, might agree to the date of the election in advance. But again, I would say these are agreements that are not falling within the confines of the National Labor Relations Act and the board's election procedures. So from an employer perspective, this is not an agreement you're entering into to tip the balance in your favor. So let's think about what does the traditional union election process entail. And this would probably show you that contrast between a neutrality agreement and a traditional election procedure. The union files a petition. The petition includes a showing of interest, which is a legal requisite that they have to demonstrate to the board that a certain percentage of the unit of employees in the potential bargaining unit have already signed authorization cards So again, that's something that is not a prerequisite in a neutrality situation. The employer is going to exercise its right to converse with its employees. I know we could say coerce its employees, some might say.
Yes, we could say.
But the union is also going to exercise those rights. The union's also going to communicate with employees outside of the work. They're going to have a barbecue and invite people to attend the week before the election and things like that. And both sides are giving up that opportunity, so there's less discourse in a neutrality agreement. Again, under the traditional election process, the board conducts a secret ballot election, and the parties maintain appeal rights. So if there was any sort of a disagreement with pre or post-election conduct, you would have the opportunity to contest that at the board. So again, these types of legally recognized and legally enforced NLRB procedures are not something that shows up when you're in the discussion of the neutrality agreement. So again, for those of you saying, hey, it's a bargain for agreement, it's a bargain for agreement between the union and the employer, so I don't see how it doesn't tip the balance somehow for the employers. So again, those of you calling bull on that statement, I would respectfully disagree. Let's talk about corporate campaigns. The bargain for a neutrality agreement is to avoid a corporate campaign, which is a very important tool in the union's toolbox. And what does a corporate campaign entail these days? The strategy is going to include, as Olivia indicated, unions are looking to organize entire industries. We're not focused as much on, let's protect this contract at Acme Corporation. We're saying, let's use this contract at Acme Corporation to unionize employees at all its similar facilities, all its competitors. It's a great philosophy, it's a great strategy. But as a result of that strategy, trying to organize entire industries, it entails not just traditional picketing or handbilling or things like that, but you might have political action, Fight for 15 campaign, Justice for Janitors, and those types of actions are, again, they're not basic political movements. They are intended to be representative of a certain ununionized workforce, and that's typically how they've been used. So Fight for 15 or predictive scheduling legislation, things like that, the unions are using to try to organize, and they're using this at employers where they're trying to organize their employees. That is what the corporate campaign is doing. Community organizing partnerships. Unions are leveraging those. So if you're an employer who has a perfectly good relationship with a community organization, you might not believe me, but it has been seen where a union will interfere with that relationship so that maybe that organization is no longer, putting its sticker of approval on that employer and is somehow publicizing that employer has lost, the sponsorship of this particular organization. The same goes for local government officials. If your business is looking for some sort of zoning or something like that, there could be behind the scenes lobbying against that as part of a corporate campaign, trying to demonstrate the power of the union, should you not choose to enter into this neutrality agreement, to control the destiny of your workforce and control the destiny of your economic ability to run your business. Also, things that have been seen in the context of a corporate campaign, white papers. Unions fund white papers, finding human rights violations, something along those lines. They publicize them. They go on NPR and talk about how that target employer is, somehow their research shows is a human rights violator. So again, the intent of that, we're all playing in the sandbox. It's an economic weapon, but it's used by the employer in the context of a corporate campaign to obtain a neutrality agreement. Not necessarily anything wrong with that, but again, from the employer perspective, the neutrality agreement is not a tool used to tip the balance of power in its favor. It's a response to avoid these types of tactics in order to be able to continue to run its business.
5 minutes, Ken.
Okay, so I will very quickly, to the chagrin of someone like Joe, say that that's not the only place that these are used. Again, this is where I'm marginalizing myself to the other side of the V. Neutrality agreements are used by employers in certain circumstances to benefit themselves. That would be situations like, say, like I gave the example, we'll organize everybody in Missouri but not in Kansas, something along those lines. why might you use that as an employer? It benefits you because you have some predictability there. You have an ongoing bargaining relationship. I think that's where you might see a neutrality agreement being more favorable or a more strategic decision by an employer to use, where you have an existing bargaining relationship with 32BJ as opposed to where 32BJ is trying to organize your work site as part of an industry-wide organizing campaign. And in that circumstance, you might be able to, obtain bargaining concessions, or you might be able to implement an employer-wide program in exchange for a neutrality agreement, something like that. So there are situations where neutrality agreements could benefit an employer or be used. I just wouldn't say it's to tip the balance of power in their favor. So knowing that I'm short on time with respect to the D.R. Horton, Murphy Oil cases, obviously the jury's still out. In response to a couple of the things that Jim had said, as far as the cheaper, more efficient, I don't disagree. And again, much to the chagrin of the employment lawyers and the management side employment lawyers in the room, there's certainly management side lawyers out there who do advise against individual agreements, because in the end, it isn't always more efficient and it isn't always less costly to have individual employment agreements or individual claims having to be litigated or in an administrative form rather than in court. As far as the no rules, there's no rules and arbitrators are more likely to split the baby. I'm sensitive to that, but at the same time, I think the way that the AAA rules are structured for employment cases scares the hell out of me as someone who does primarily labor, where there's almost no rules. I do think that the employment rules at the AAA and similar forums for employment cases are much closer to a court forum than a traditional labor type forum where the rules apply a little bit less. And so that brings me to the last point, which is obviously, Jim talked a little bit about the equity arguments. I'm sensitive to some of that, but I wanted to focus more on the legal piece of it, which is focusing more on the Murphy Oil case and Epic and Ernst & Young, which are likely to be decided soon. I think the primary issue there, I doubt I'll have time to get through it, but again, the Fifth Circuit decided that there was no statutory right to engage under the NLRA to participate in these class action lawsuits. The Seventh Circuit and Ninth Circuit, with a little bit different, found that there was a statutory right pursuant to the other concerted activity. I would just highlight for you that the primary argument, I believe, at the Supreme Court from the employer side was that Supreme Court precedent says that the FAA can be overridden, but it can be overridden by contrary congressional command. And that becomes one of the primary issues in these cases. So if you look at any of the briefing or when the decision comes out, I would imagine that will be a focal point. And the question I would have for you, that I'm sure would be a much longer discussion if we had more time, is, does the NLRA clearly provide a substantive right? Does the NLRA provide that contrary congressional command that would override the recognized implications of the FAA, which is in favor of private arbitration agreements? The plaintiffs did not argue that. Plaintiffs did not argue that class action waivers are illegal under the FLSA. All of these cases involve the FLSA. So if you think for a minute about this, the FLSA, you can waive your right to participate in a class action under the FLSA. So it's difficult from my perspective, and I would imagine I'm representative of other management lawyers, that somehow the NLRA confers a right to pursue class claims that the statute enforcing those minimum wage or misclassification laws does not otherwise enforce. That seems like a bit of a stretch. Okay, and that's how we get to this, is that the FLSA, if it in and of itself is not, trumping the FAA, then how is the National Labor Relations Act trumping the FAA with respect to claims under that law? And then as far as depriving them of substantive NLRA rights, Section 7 rights, again, the policy of the NLRA is to ensure the free flow of commerce, protecting freedom of association, self-organization, designation of representatives for collective bargaining purposes. So within that, the argument on behalf of the employees in these cases is that within that frame of reference, there is a right as well to participate in collective actions as other concerted activity. And so again, the argument from the employer side, which I would subscribe to, is the Section 7 right really implicated in these suits? Is this right to participate in a class or collective action really implicated by the other concerted activities language? And if the statutory language of Section 1 and Section 7 of the Act is self-organization, freedom of association, designation of bargaining representatives, and the ability to engage in collective bargaining negotiations so that we don't interfere with commerce through labor stoppages, again, there's a disconnect there, in my opinion, and from the management bar's opinion, and this is what was argued at the Supreme Court, between that premise of the National Labor Relations Act and how somehow that translates in the, this overarching clause of other concerted activities, that other concerted activities somehow affords a substantive right to participate in a legal proceeding. I don't believe that's implicated in the statutory purpose or in the statement in Section 7 of the rights that employees have under the Act. So one last thing, and I'll end. I think obviously this is going to be a 5-4 decision, and both sides of the V are going to complain that it was highly politicized. One of the cases that's cited heavily in the briefing is CompuCredit. CompuCredit is a 2012 decision under the Credit Repair Organizations Act. So again, it's a little bit different, but it is an FAA preemption case. And that case was actually a much stronger decision in favor of the strength of the Federal Arbitration Act. It was a Scalia decision. It was joined by Chief Justice Roberts, Justice Kennedy, Justice Thomas, and Justice Alito. But Justice Breyer joined in the majority opinion. Justice Sotomayor issued a concurring decision which Justice Kagan concurred with. So if you look at that decision, again, it's a little bit different, but I would argue that it's not necessarily divided by liberal lines. This is an FAA question. This is not necessarily a employee rights question at its core. But I think everyone in the room probably disagrees with me on that.
So let me just add two things from a neutral's perspective. First of all, as an arbitrator, I concur, and I'm relieved that, in fact, employment arbitrations are not cheap. The second point, interesting, sort of be careful what you wish for anecdote. I was involved actually in mediating. It started as a wage and hour Fair Labor Standards Act claim against a chain, enormous chain of restaurants. Restaurants commit untold wage and hour violations.
Allegedly.
So the case actually got initially filed in court. That was conditionally, the class was conditionally certified. They proceeded. The employer went in and said, "Oh no, we have a mandatory ADR process, which has mediation and then arbitration." And one of the things, at least to date, under mandatory arbitration, employer promulgated plans, employer has to pay for the process. I don't know with the Supreme Court whether that tenet will last, but so far it is. So clearly the employer's strategy in any of these mandatory arbitrations and class action waivers is to say, well, each individual claim is not worth much, no one's going to bother to pursue it. Plaintiffs' lawyers are not dumb, and they know this is a lucrative area. They are now forming networks, and they say, okay, can't proceed as a class, we'll file 5,000 individual claims. Employer has to pay the AAA, employer has to pay for the mediators, employer has to pay for the arbitrators. The really clever plans require 3-member arbitration panels. And I know situations where the employers say to plaintiff's counsel, "Oh, well, you would agree to waive that." And they said, "Absolutely not. We're looking for the 3 most expensive arbitrators." So in mediating this, I calculated that if the employer won every single case, which there was no way, but assuming they won every single case, they went through mediation and arbitration, the transaction cost, not including their attorneys, would be $80 million. And you say, ooh, clever plan. Okay? So there is a consequence to doing that. I also know of a situation where this was fought up and down, First Circuit and down, on the issue of, it was with the cleaning contractor situation, and the employer got the court to agree that for most of the people in the class, they were bound by mandatory arbitration, no class action waiver. Plaintiff's counsel says, okay, we're on, first case. They litigate the first case. They get the claimant $10,000. They get $150,000 in legal fees. And they say, okay, second case. And they go in, and then the same thing happened. After the third case, the employer calls up and says, geez, you think we can do a class action settlement here? So class actions actually have a function. And they, related to efficiency, common legal issues, and the rest. I also have a question about issue preclusion. And if it's an individual, the individual loses the first case, okay, that's not binding on the next individual. I have a question about if, as soon as the employer loses the case, whether that's binding on the employer. And you could then have a legal ruling which you can take to court, you can appeal. That's the one thing about arbitration. When you get the award, it sticks. So, I don't know that it has been yet litigated. I know it's been argued to me as an arbitrator by an employer against a pension fund that there was issue collusion. So I think it's an interesting question of, what is going to play out with what I think is probably the inevitable Supreme Court ruling.
And I think, to your point, I think there was a question at oral argument on the Murphy Oil case with that specific example that, can't 1,000 of these employees bring individual cases? Isn't that still concerted activity if they're using the same law firm or the same group of lawyers? And so again, that is a question that I think came up, and I don't know if it will factor into the ruling at all, but from an academic standpoint, I don't know, would that allow people concerted activity if they're not allowed the ability to bring a class action, but they're allowed to bring 1,000 individual actions utilizing the same lawyer? Is that still allowing them to engage in protected activity? And then one more thing, which if this is obviously settled in the next couple of months, which would be the class action waiver piece, these cases, the three cases before the Supreme Court, all arose from the FLSA context and eventually a board charge being filed. One thing that's happening, I think, more recently than that, and we've seen it now, is actually board charges being filed for misclassification cases, alleging that misclassification in and of itself is a violation of the Act. And there was, I think, the first one, but Professor Clare might know better. I think just in the past couple of days, there was an ALJ decision in California that subscribed to Richard Griffin's theory that if the general counsel's theory that simply misclassifying an individual was a violation of the Act. So maybe that's the next battleground after class and collective actions.
Great. Well, thank you very much, panel. We appreciate it. Okay, we're just going to switch. Stay where you are.
So,
Then if you have further questions after, just ask during the networking reception.